Shelly-Ann Balwah, his mother and next friend. Against Marwan Ahmad Alsayed and Surgi-Med.
Mr. Brown.
Please, Your Lordship. Overnight, and in the light of yesterday's submissions, my own friend Mr. Callow and I have largely reduced our submissions to writing. We do have copies of the court would like, and of course entirely in your hands as to whether you would like them or not.
Which actually, yeah, I think we just mistake. Yeah, I think so.
Mr. Brown, we're very grateful for the effort that's gone into it, and it's the usual practice of the court not to receive further written submissions.
Very well, the Lord.
But we are grateful.
It was just an effort to say the judicial pen.
Always a relevant consideration.
May it please the Board, we will address in our submissions the issues raised in the Statement of Facts and Issues before the Board, pages 27959, 2760, namely, 1, did the Court of Appeal err in reversing the judge's factual findings of Dr. Abdullah's arrival time? 2, if it did not, did it err in entering judgment against Dr. Abdullah, and in particular, 1, was it correct to find the brain damage was caused in the second stage of labour? 2, was it correct to find that as a result the elements of causation and negligence were established? And then lastly, page 2760, if the Court of Appeal was correct to find that Dr. Abdullah was liable for Aeden's injuries, should that finding also be applied to the clinic? So those are the structures of our submissions. And I start, therefore, by consideration of the Court of Appeal's decision. And the opening question clearly is, was the Court of Appeal entitled to overturn the findings of fact? As the Board will recall, the Court of Appeal really relied upon 3 factors as indicating that it was entitled to overturn the findings of fact. 1, the judge drew illegitimate inferences as to the significance of full dilatation at 4:30 a.m. That's judgment, paragraph 128, paragraph 179, page 128. 2, the judge failed to take into account Dr. Aguilar's letter, that's page, paragraph 180 of the judgment. 3, there were no notes upon which the judge could rely, and as such, Dr. Abdullah should have been held to his pleaded case. I think we've looked at that paragraph, paragraph 182, but in our respectful submission, the phraseology is potentially important, and I would therefore invite your attention back to it, if I may, for a moment. So it's page 129, paragraph 182. Accordingly, it is my view that the judge was plainly wrong in so doing. Having rejected viva voce evidence of the witnesses of fact, both the appellant and the second respondent, and having no notes upon which to rely, the judge should have been left only with the pleaded admission of the second respondent. I place emphasis, as the Board will realise, on the word no in that context, and I'll come back to that. In looking at the rectitude or otherwise of the Court of Appeal's overturning of the findings of fact, may I start by looking at the principles of what we've called in our written case judicial deference. Reference was made yesterday to Gift and Rowley. It's accepted, I think, that the test in relation to appeals from Trinidad and Tobago is the same as the test in England. Namely, that in order to overturn, the Court of Appeal must be satisfied either that the decision was plainly wrong or that it is rationally insupportable. The appellant suggests that the same test applies before the Board when it considers overturning the Court of Appeal's decision. That's probably most easily observed at page 2797, if I may take you to that.
plainly not right. And the prior question is whether the first instance judge is plainly wrong.
Well, Lord, you have my submission. The principle of judicial deference arises out of the advantage that the trial judge had of hearing the witnesses, being familiar with the case, and so on, and one can see that from the authorities. The same deference is not due to the Court of Appeal, who of course lacked all those advantages. So the test is not whether the Court of Appeal was plainly wrong, but whether it was justified in what it was doing or not. Next, by way of principle...
How does that sit with the concurrent findings of facts, insofar as if both the Court of Appeal and the First Instance Court has concurrently found the same facts? How does the test then apply to the Court of Appeal's determination?
I'm not sure I entirely understand your lordship.
Well, you say that there's no deference shown to the Court of Appeal's decision, but in the concurrent findings of fact, you'd have to establish that both the Court of Appeal and the First Instance judge were plainly wrong. Well, plainly actually doesn't add anything to it. They were wrong.
Yes.
And so therefore, you have to apply the test of wrong to the Court of Appeal's determination, as well as to the determination by the First Instance judge.
Yes.
So I was wondering whether you can quite box it off on the basis that there's absolutely no deference shown to the Court of Appeal.
Well, there's concurrent findings of fact, my lords. In other words, the same facts have been found by both.
It's still a factual finding. But anyway.
Then the test is whether it's wrong. But where the Court of Appeal is seeking to overturn the findings of first instance,
Yeah.
then in our respectful submission, the word plainly, which your lordship says
Yes.
adds little, but
Yeah.
perhaps adds something in those circumstances, or the alternative explanation, of course, is rationally insupportable.
Yeah.
And I'll come back to that. And that test, we respectfully submit, does apply to the Court of Appeal interfering with findings of fact
But by the first instance, yes.
not to this court or this board interfering with findings of fact of the Court of Appeal.
No, it doesn't really arise anyway.
So that's the... Secondly, we respectfully submit, and this appears from Volpe, and I think we saw the passage yesterday, that the mere fact that a document is not mentioned should not lead to a finding that it was ignored. I'll come back to that. Aeden argues that the Trinidad and Tobago approach to amendment is stricter than the English CPR approach. Even if that's correct, all the cases relied upon by Aeden relate to one party or multiple parties adopting the same approach, as in Teixeira, where none of the two relevant parties had amended. Further, in the cases we respectfully submit that in which the parties have been held to their pleadings, the nature of the relevant issue has been fundamental. By way of example, the existence of a specific duty in Teixeira, or whether a notice, a requisite notice, was served, as in Loveridge. So I turn then to the question of whether the Court of Appeal was entitled to conclude that the judge's judgment was plainly wrong or rationally insupportable. First ground of that decision, as I've said, is whether the trial judge drew an illegitimate inference. That relates, of course, to what the significance was of the note of full dilatation at 4:30. The Court of Appeal concluded that there was no evidence in support of that the judge is therefore drawing an illegitimate inference. As we saw yesterday, there was indeed direct evidence in support of the significance of that note at 4:30. We looked at the evidence yesterday. It's page 1723, line 27, to 1724, line 8. It's within the cross-examination, or it's the questioning of Dr. Jayasimi by the judge, and effectively it was said, as by Dr. Jayasimi, that there would be no point in recording full dilatation, partly through an attempt at labour, because you don't start trying labour until you get to full dilatation, which of course is the beginning of the second stage. So that when the Court of Appeal concludes that there is an illegitimate inference with respect to them, there was no inference. The judge was entitled to reach that conclusion based upon the evidence he's heard, and heard, interestingly, in answer to his own questions. Accordingly, we submit that the first ground relied upon by the Court of Appeal for overturning the trial judge's findings of fact falls away. Secondly, whether the trial judge ignored Dr. Aguilar's note. As the board will recall from yesterday, the trial judge recorded the contents of Dr. Aguilar's note in his judgment, paragraph 7, pages 33 to 34. I don't take you to it, we saw it yesterday, but effectively, that paragraph records all the important elements of the note, Dr. Aguilar's note in the case. The note itself, if the board would wish to cross-refer to it, is at pages 453, 454. But comparison of the judge's paragraph with that note will demonstrate, we submit, that the judge clearly was fully aware of the document and of what it said. As Mr. Strang submitted yesterday, it's also not clear why the Court of Appeal considered this was supportive of the 4 o'clock timing. It may be because of the mention of prolonged labour, but as was discussed yesterday, this labour, even on the claimant's timings, was 4 hours, 4 o'clock in the morning to 6:15 in the morning, 2¼ hours. And on Dr. J. Asimi's own report, page 808, prolonged labour did not occur in a prima gravida unless it was 3 hours or more. So if the Court of Appeal was saying, well, look, he's saying prolonged labour, that contradicts what the judge was concluding, with great respect to them, they were wrong. He was describing prolonged labour, but that was not, the periods did not qualify for prolonged labour in this case, on any view. There's no evidence that Dr. Aguilar was present during the attempted delivery, so insofar as he deals with those aspects, it must be based on something else, but certainly not his own observation. And in those circumstances, we respectfully submit that the weight to be attached to the document was peculiarly a matter for the judge. Accordingly, it was wholly inappropriate for the Court of Appeal to attach its own weight to a document the judge had seen and considered, and substitute its own conclusion for the conclusions of fact of the judge. The third ground, as we've already respectfully indicated, is whether the trial judge should have held Dr. Abdulla to his pleadings. And in the first instance, as you would expect, we defer to Dr. Abdullah's submission, since this a point that concerns him rather more than it does us. We do submit that there's a distinction between a case in which all parties on the same side plead the same facts, and a case where one party, with the consent of the opposing side, and I stress that, has amended putting the point in issue. That, of course, had occurred here, and in such circumstances, we submit it was for the judge to determine the issue. It would be absurd if the judge was entitled to find the doctor arrived at the clinic at one time, vis-à-vis the first respondent, but was constrained to find he'd arrived at another time, consequent upon the pleadings of the second respondent. Dr. Powers argued yesterday that because the clinic could not call direct evidence from its employees or experts on the issue of timing, the clinic was precluded from arguing the relevant timing was 4:30 to 5:30. This, as I think my Lord Burnett said, ignored the evidence of Dr. Abdulla in cross-examination, where he was saying in terms that the timing was 4:30 to 5:30, and of course we were entitled to rely upon that as part of the evidence in the case. For what it's worth, that evidence was given after permission to amend was granted on the 21st March, in that Dr. Abdulla was cross-examined on the 26th March. In addition, and this is why I was stressing the no in paragraph 182 of the Court of Appeal judgment, if, as we respectfully submit he was, the judge was entitled to rely upon Nurse Hoston's note, then the circumstances envisaged by the Court of Appeal did not arise. There was evidence in the notes upon which the judge could rely, and it would seem, according to the Court of Appeal test, that in those circumstances they themselves would not have held the judge constrained to act in accordance with the Abdulla defence. Lastly, on this issue, the nature of the pleadings to which Aeden seeks to hold Dr. Abdulla does not relate, we respectfully submit, to a fundamental issue, unlike Tashira or Loveridge, to which I've already made reference. This was a pleading to a part of a preliminary chronology within the amended or re-amended statement of case. That is not, we submit, akin to whether there's a duty or not, as in Tashira, whether a requisite notice has been served or not, as in Loveridge. It's a very much more peripheral issue. And the consequence of that...
Or at least at the outset was.
Well, yes, and my Lord, there was a point, Your Lordship, I think, a question I think Your Lordship asked yesterday, which is at what point in the trial did this period become so important? Certainly one of the board asked the question yesterday. And I'm afraid, despite my best efforts, I don't think it's apparent, but it is clear that it had become a central issue by the time of the judgment, and it's certainly not suggested by my learned friend Dr. Powers that it had not. So that everyone, and the judge has said this is an agreed qualification. Was there time for the injury to be suffered? There might have been 4 o'clock to 5 o'clock. There would not have been 4:30 to 5:30, and that's agreed. And nowhere is it suggested that it had not been agreed. So I'm afraid I can't assist as to the time during the trial when that became apparent. But as so often...
Certainly my impression from reading the materials that we have is that it was once the experts had given their evidence,
yes,
essentially. That.
Lord, I respectfully agree. I think the answer is, as so often in a case of relatively heavy and expert evidence, it was as the evidence developed that the importance of that point became ever more significant.
Well, just looking at Rule 20.1,
yes,
that requires permission in relation to a change in the statement of case, which includes the statement, obviously, of defence. It doesn't say a fundamental change, it says a change.
yes.
So are you seeking to suggest that because it isn't a fundamental issue, and it doesn't fundamentally, it fundamentally relates to the chronology rather than a major issue in the case, that it somehow doesn't fall within Rule 20.1? And if so, I'd be interested to know why.
No, my Lord, I'm not making that submission.
Right.
The submission I make is this, that in the circumstances of this case, where you have one party which
Well,
is
that's the absurdity point.
and another party which is not,
Yeah.
it is then for a matter for the judge to decide the extent to which he should be bound by the non-amending party's pleading, if I can put it like that.
Right. Okay.
So it goes to the exercise of judicial discretion in those circumstances as to whether the judge bows to what your Lordship's just called the absurdity point, or whether the judge holds the view that this is a strict pleading point to which he is bound. I'm not, therefore, making the submission your Lord suggested I might be, but I am saying that since it arises in the case necessarily because of our amendment, so at that stage, the judge is entitled to look at all the circumstances, including the importance of the pleading, the remaining pleading of Dr. Abdulla.
It is relevant to where the interests of justice lie.
Well,
You're
my Lord,
trying to determine that.
yes. So that's how I know my learned friend, Mr. Strang, is going to adduce in his reply a copy of the Trinidad and Tobago overriding objective requirement.
Yes, but I've had a look at it.
Don't infringe on his submissions in that regard, but he will no doubt have more to say so far as that's concerned in due course.
Mr. Brown, how do we deal with what might be thought to be contradictory pleadings within the same document, or at least ambiguous? So if it's suggested that Dr. Abdulla is bound by his pleading to paragraphs 18, subparagraph G and H, is he also bound by his pleading in paragraphs 34, 21 and 23? And how on earth is that resolved when they, as it appears to me, are contradictory?
Well, Lord, it goes back to the observation Lord Doty's just made, we respectfully submit. It all comes down to the question of justice. One looks at the whole of the document, where the document unequivocally and repeatedly pleading, it's 4 to 5. Our case is very clearly 4 to 5. That would be on one side of the equation, on the balance. If, on the other hand, when you look at the totality of the document, you can say, well, I'm not really sure where this ends up, then that would end up on the other side of the balance, and the judge would be entitled to say, well, I suppose, au fond, the judge might be entitled to say, I'm not even quite persuaded that there is an unequivocal pleading to which they could be held. But at the very least, even if there is, as my own friend Dr. Powers suggests, an unequivocal pleading to which they might be held, it must go to the question of whether they should be held to it. And that, as I've said, is really all coming back to the justice of the case.
Yes.
In addressing the...
I must admit to being slightly more enthusiastic about an ultimate reply to that question than the last, because in Trinidad and Tobago, they have quite deliberately set about having a stricter rule than applies in this jurisdiction. And that's their decision, and that's their law. And it may be more an interpretation of what the pleading actually says, rather than holding a person to the pleading. Yes. So there might be interpretation of the pleading. What is the proper interpretation of this pleading?
Yes.
As opposed to holding somebody to their pleading, which we most certainly did in Gulf View. We held them to their pleading.
Well, Lord, I've made the submission about the importance of the pleading to which you were holding to Shearer in that case, or Gulf View in that case. Yeah. I won't repeat that. But I respectfully agree. It's, as I think I've said, it would be one thing if it's a clear pleading, where one can see very clearly what the party's case is, to hold them to a pleading. It may be another where you say, well, on the totality of the pleadings here, I'm really not quite sure what they are saying. Yeah. And of course, one of the other aspects, I say of course, one of the other aspects, which perhaps we can see from this case, of litigation in Trinidad and Tobago is that the parties are not slow to take out applications to clarify what is being said in pleadings and so on and so forth. So my learned friend could certainly have dealt with my Lord Burnett's point by taking out an application and saying, well, look, there are all these contradictions in your defence. What is your case? What are you saying? Are you saying full dilatation at 4:30 with delivery 4:30 to 5:30, or are you saying 4 to 5?
Yeah. Well, for my part, I'm quite, at the moment, of the view that the pleading is unclear, that on its proper interpretation, it doesn't tie Dr. Abdulla to a particular time. And, but if it did, then I would have thought that a change, it would fall within the need to change, to amend the pleadings, because there would be a change. If the proper interpretation of the pleading is that he did categorically tie himself to 4 to 5, then that would be a change, falling within Rule 20.1.
Subject to the point about the importance of the issue to which the pleading, that part of the pleading goes, which I made my submissions on that, I would respectfully agree with your Lordship.
Yeah. Okay.
It's also, we respectfully submit, relevant to ask whether there is other evidence supporting the rationality of the judge's findings. First, Dr. Abdulla records that the decision for LSCS STET was taken at 5:30 after an hour-long attempt at vaginal delivery without any progress. My Lord, it may be a little surprise to the court, to the board, to know that STET is a misreading. The word is stat, which of course is an abbreviation of the Latin, I say of course, is an abbreviation of the word statim, which means immediately or without delay. It's a very well-known piece of medical jargon, if I can put it like that. So that what is being written at 5:30 is there needs to be an immediate caesarean section. And this is recorded in the trial judgment at paragraph 82 and at paragraphs 36 and 37 of Dr. Abdullah's witness statement, page 771. I don't take you to it. And I think we saw yesterday that in evidence Dr. Abdullah confirmed that the decision was made at the end of an hour-long attempt at delivery in his evidence. Importantly, it doesn't appear to be disputed that 5:30 a.m. was the point at which the decision was made, as it is averred by Aeden at paragraph 26.1, his reply to Dr. Abdullah's defence, and it's page 319, and it might be worth looking at it.
319.
319, Lord, yes. It's the bottom of the page, paragraph 26.1. The decision to do a caesarean section was not made until 5:30 a.m., thus incurring an initial delay of 30 minutes. And in the Aeden's factual background before the board, it records that Mrs. Balwah was moved to the operating theatre at 5:30. That's 2641. I don't take the court to it, but there is that reference. Importantly also, Aeden has produced no logical explanation as to why there might be a delay between the end of the attempt at active labour with no progress and the decision to carry out a caesarean section. Clearly, by the time the decision was made, Dr. Abdullah considered that it was urgent, hence stat. And it would seem extraordinary, we respectfully submit, for him to try labour for an hour from 4 till 5, and then hang around for half an hour, and then make a decision for an immediate caesarean section. We respectfully submit that that body of evidence, when taken together, is capable of supporting the rationality of the judge's conclusion on this issue. Secondly, the note of Dr. Abdullah, it's the same one, I don't take you back to it, but it's within the Court of Appeal judgment, at least a partial quotation, at 126, 127, records that the fetal heart rate was regular during attempts at delivery. At pages 2109 to 2110, Dr. Abdullah was cross-examined by me as to the various sorts of fetal heart rate abnormality that might have occurred if the fetus was suffering from chronic partial hypoxia in the period up to the end of the attempted delivery. Those were, of course, bradycardia, very slow heart rate, tachycardia, very high heart rate, and fast heart rate, or late decelerations, in other words, the heart dropping after contractions. Dr. Abdullah was saying that any of those would have been detectable on the Doppler monitoring, both audibly on the microphone and visually on the monitor, had they occurred during that period. And my Lord, on this topic, whilst it's right that the trial judge recorded at para 142 of his judgment that Dr. Abdullah did not have a recollection independent of his notes, he was, we respectfully submit, entitled to give his interpretation of his own notes and to tell the court how he would interpret those notes now. That applies both to the question of when the note was made, the question of arrival at 4 o'clock, and so on. But critically in this context, which I'm dealing at the moment, Dr. Abdulla was entitled to give evidence that there was Doppler monitoring, because that's what was done in those days, and he recalls that much, and to, in answer to me, to say that had any of the fetal heart rate abnormalities, which on the learned friend Dr. Power's case must have been present, and indeed probably common ground that one or other must have been present, must have been detectable on the Doppler monitoring that was being carried out at that stage. In other words, the distinction I'm seeking to make is between, on the one hand, an independent recollection. The judge says he has none, he admits he has none, and therefore I don't accept any independent recollection he may produce, and a recollection based upon interpretation of notes, where he has a contemporaneous document, which gives him the ability to say, well, that's what I've written, and I would have written that because, if I can put it like that, was my usual practice. So again, when one looks at that body of evidence...
Was there any reference in the notes to Doppler at all?
No, no, there's not.
Was there any reference to Pinard, stethoscope? No. So there's nothing in the notes to say how the monitoring took place?
No. But one of the allegations...
And he gave his evidence as to his usual practice,
yes.
Therefore?
Yes, that's right.
And the judge placed absolutely no reliance on that.
Can I deal with that in two parts?
Yes.
Yes. That comment, of course, is correct, my Lord. The judge did not place reliance upon it.
Yeah.
The issue I'm seeking to address at the moment
is the interpretation of the notes. That's perfectly valid.
Is whether he would have been entitled to take that evidence into account, even having rejected any independent recollection as he did, whether the judge could nonetheless have taken that evidence into account in support of his finding of fact. And the submission I'm making is yes, he could, because a professional man...
He could have taken into account that there was a Doppler actually being used as opposed to Pinard, and that was audible, and Dr. Abdulla would have reacted.
Yes.
Even though he had absolutely no recollection at all of whether a Doppler was used.
The point I seek to make, my Lord, is that Dr. Abdulla should be entitled to give evidence as to what his practice was at that particular time. We know that he was monitoring, because we've got FHR, that's within the note. The next question is, how would you be monitoring? He should be entitled to say, well, as at that date, it would be a Doppler. Now it would be a cardiotocogram, as you know, but in those days, it was a Doppler that was used. That was what was used at the clinic, and I can tell you, therefore, that that is what would have been used.
Where did the judge make any findings about that?
Yes, that's true.
Where did he make any findings?
He didn't.
He didn't?
No, he didn't. No, look, the submission I'm seeking to make is this. Not that the judge made findings in this regard, so that the Court of Appeal ignored findings the judge had made which were clearly capable of supporting the evidence, but rather that when you look at the body of evidence, that is capable of supporting the rationality of the judge's conclusion, so that we respectfully submit that when you ask the question, is the conclusion rationally and supportable, there are, as I've already submitted, areas of evidence which would be capable of supporting the rationality of the decision. To put it at its lowest, they certainly don't go the other way. In other words, they certainly do not serve to support the irrationality of the judge's conclusion.
Thank you.
Lastly, so far as this is concerned, Dr. Powers, in submission, seeks to support his case as to, well, it must have been 4 to 5, I think in reliance upon what he perceives as what must have been the interpretation by experts of the notes as to timing. Well, with great respect, it's not a matter for an expert to reach conclusions of fact. It is for them to set out the material upon which they rely and then to give their professional view, but not to seek to adjudicate upon issues of fact that arise between the parties. That is the function of the judge and for lay witnesses to comment, as indeed happened here. Lastly, on this topic of whether the Court of Appeal was entitled to interfere, there is, we respectfully submit, further material to undermine the Aguilar account, which they say should be preferred to that of the judge's conclusion in relation to Nurse Hoston's full dilatation note. I don't want to repeat myself, but we've seen that Dr. Aguilar recorded the second stage of labour as being prolonged, and for the reasons I've already submitted, that is clearly wrong. On either timing, the labour did not last more than 2 hours and a quarter, and the definition of prolonged labour for prima gravida such as Mrs. Balwah is 3 hours plus. So that if you say on the one hand, well, we've got midwife Hoston's note, not sure, doesn't seem to be anything wrong with it, but where does it take you? We say, well, Dr. Jayasimi takes you to, it must be full dilatation at 4:30, must be the beginning of the labour, 4:30. And you put in the other side of the balance, as the Court of Appeal did, Dr. Aguilar's note. Well, firstly, as I've said, one asks the question, well, where does it take you? I don't repeat myself on that. But secondly, there are grounds in relation to the note of prolonged labour for saying, well, it doesn't seem to be quite accurate in relation to an account of the events which in fact occurred, whichever party is right about the timing issue. And therefore, again, I come back to it. We respectfully submit that the judge was entirely entitled to rely upon the midwife Hoston note, together with Dr. Jayasimi's interpretation as to the significance of full dilatation, and the Court of Appeal is therefore wrong to overturn that finding of fact. That was all I was proposing today to say about the first issue before the board. I'll move on, if I may, to issues of causation, which are, as the board will fully appreciate, twofold. Was the Court of Appeal correct to find damage was caused in the second stage of labour, in other words, the timing point? Secondly, was it correct to find that as a result, causation and negligence were established? We make effectively 4 submissions. The first is this, and it's perhaps painfully obvious. Did the trial judge, we asked the question, did the trial judge conclude that if the claimant succeeded on the timing argument, it was established that the cause of the claimant's injury was intrapartum VPHI? And my Lord, we come back to paragraph 147 of the judgment, where the judge said in the circumstances, the claimant's case must be dismissed. It is not necessary for me to take the further step and consider further whether the breaches of the duty actually caused the damage, as it is not possible for them to have done so. He's making it pellucid that he's not reaching findings of causation. And, my Lord's Lady, possibly significant, Dr. Powers doesn't appear to seek to circumvent that paragraph in his submissions. He simply ignores it. And of course, the circumstances are these. The trial judge had surveyed the expert evidence throughout. He'd considered various possibilities for the mechanisms of the injury, but made no findings, and says so in terms. And this is reflected further, should it be relevant, in our written case, paragraphs 39 and 42. Page 2855. Second issue, even if the trial judge made no such findings, was the Court of Appeal correct to conclude that Aeden should have succeeded in establishing that the cause of his injury was intrapartum PPHI. The mechanism of injury remained unresolved. Whilst the viral explanation was considered less likely, and I accept that, and indeed dismissed by Dr. Wilkerson, there remained, as you can see just reading the judgment, very considerable expert evidence present before the trial judge to suggest that the injury could have occurred prior to labour, and indeed, on Dr. Wilkerson's view, that it had occurred prior to labour. That's the trial judgment 60 to 64, where Dr. Wilkerson's evidence is recounted. Further, as acknowledged by the expert witnesses, and I just give you the references, if I may, I don't take you to them, page 1975, pages 1248 to 52, and 1312 to 1314, the criteria set out in the ACOG guidelines, quote, marks of an acute peripartum or intrapartum hypoxic ischemic event, were critical in investigating a supposed causal link. I'm not sure we looked at those criteria, and it may assist the court to look at them now. It's at page 2347. I'm so sorry, I got the wrong reference. 2437. The history, as the board will recall, is that there is an earlier document, which is to be found immediately preceding this one, starting at page 2431, in relation to, produced by the American Association. And in that document, as one can see from page 2433, the October 1999 version, it said, if I can take you to page 2433, left-hand column, unavailable or contrary evidence, all three of the essential criteria are necessary before an intrapartum hypoxic event, hypoxic cause of cerebral palsy, can begin to be considered. If any one of the essential criteria is not present, it strongly suggests that the intrapartum hypoxia was not the cause of the cerebral palsy. And looking at those essential criteria, you have essential criteria 1, evidence of a metabolic acidosis in intrapartum fetal umbilical cord gases, or very early neonatal blood samples, early onset of severe or moderate neonatal encephalopathy. And it was not, I think, seriously suggested that those three criteria were fulfilled. But more time was taken, as I've already said, I think, on the document at 2437, and it was agreed that these were the markers which should be looked at in investigating whether there was intrapartum hypoxic ischemic, an hypoxic ischemic event. And critically, and I know my Lady Wise was mentioning this yesterday, you need APGAR scores of below 5 at 5 minutes and 10 minutes. They were not. You need fetal umbilical artery acidemia. There was very little evidence of, there's no sample taken, but such evidence as there was did not suggest acidemia. Neuroimaging evidence of acute brain injury cerebral consistent with hypoxic ischemia. Well, there's a CT here which has that. And then importantly, presence of multi-system organ failure consistent with hypoxic ischemic encephalopathy. I'll come back to that in a moment. But a convenient starting point in relation to the question of whether the neonatal condition was consistent with a very severe hypoxic ischemic insult at the very end of labour, and that, of course, is the claimant's case, is dealt with comprehensively by Dr. Wilkerson, that's 1822 to 1824. He says, no, this baby was substantially too well for it to have had that sort of insult at the very end of labour. And by Dr. Sinkhorn, that's 1972 to 1973. Dr. Milligan, the neonatologist for the claimant, in evidence agreed that the requirement for APGAR scores for below 5 at 5 minutes and 10 minutes was not fulfilled. That's page 1312.
Sorry, just say again, that was who?
That was Dr. Milligan, my lord, the
yes, thank you.
neonatologist for Aeden. He agreed that the APGAR scores were not fulfilled, so the first marker of those is not fulfilled. Further in evidence, he was suggesting that I think there may have been some effect on the kidneys. In other words, another organ failure, if I can put it like that. But he did not seek to postulate any other organ involvement. It's trite, but of course a multi-system organ involvement means more than one organ. And the reason for that, as the board will readily appreciate, is because in order to preserve the functioning of the brain, when there is inadequate blood, the body will switch its defense mechanisms so that less blood goes to the internal organs and more blood goes to the brain, the most important organ, so as to preserve the functioning of the brain. It's all dealt with in the evidence. I don't take you to it, given the time limits, but if you read the evidence, it's not of any interest at all. If you read the evidence of Dr. Wilkerson and Dr. Sinkhorn, you can see that they deal with that in that way. But most importantly, perhaps, when we come back to the markers of acute peripartum or intrapartum hypoxic ischemia, even Dr. Milligan, on behalf of Aeden, agreed line at page 1314, lines 13 to 17, and it might be helpful to go to this. And he was, this is cross-examination by me, page 13, 14, line 13, having gone through all these various different requirements of the document at which we've just been looking, I asked this. At the very least, Dr. Milligan, when you look at the consensus statement, the most recent criteria, you must presumably say to yourself, well, it doesn't really fit. It might fit, but it doesn't really. And he responded, I would agree. It doesn't fit very neatly. So even on the evidence of Dr. Milligan, firstly, he agrees that the APGAR qualification, if I can put it like that, is not fulfilled. Secondly, he postulates some kidney involvement but is unable to point to a multi-system failure. And thirdly, he is constrained to agree that it doesn't fit very neatly.
He slightly rose back from that at line 21, doesn't he?
Yes. So, coming back to the submission, if one asks oneself the question, well, on the evidence before the judge, was causation established? In other words, he must have been deciding intrapartum hypoxic as being the cause. The answer quite clearly is no. On the neurological, neonatological, and other evidence, there was a very strong dispute, and a strong dispute which could be justified and supported by reference to what everyone agreed to be the prevailing and highly authoritative guidelines. As my learned friend Dr. Powers said yesterday, effectively the neuroradiological evidence of that CT scan was equivocal. it demonstrated that there was damage, eventually, if I can put it like that. But the joint statement, and the board has clearly looked at that, was unable to date when that damage would have occurred by reference to the scan. So little help there. The remaining point is that Dr. Wilkerson gave evidence that the degree of injury is far too much to be explained by a hypothesis of simple, partial, prolonged hypoxia. And he goes on to say, my Lord, it's the judgment, paragraph 101, page 64, where this is quoted. The degree of injury shown both clinically and by the 2014 MRI scan is far too much to be explained by a hypothesis of simple, partial, prolonged hypoxia. Further, had there been a hypoxic ischemic injury, one would expect to see no urine. That, of course, is a reference back to the multi-system failure point and the question of whether there had been kidney failure has been suggested by or kidney effects, as had been suggested by Dr. Milligan. Dr. Wilkerson said no. Had the kidneys been non-operational, if I can put it like that, then you would expect to see no urine, and there is urine recorded against all that. Yeah. So, if one asks the question, looking at the evidence given before the judge and extensively reviewed by the judge, is one driven to the conclusion that if it's 4 to 5, then it's intrapartum damage? The answer quite clearly is no. There is a very substantial dispute upon the expert evidence, and a dispute which the judge expressly did not resolve. The Court of Appeal, of course, did seek to resolve it in this sentence. The inescapable conclusion is that the appellant should have succeeded in establishing causation. That, as far as I can see, is really all they say on this issue. That probably arises because in his submission to the Court of Appeal, Dr. Powers was saying, if the finding of fact is overturned, causation follows. For the reasons I've already dealt with, we respect that that submission is apparently misconceived, and one which the Court of Appeal, upon proper examination, could not have come to that conclusion.
And the Court of Appeal doesn't discuss the evidence or give any reasons for saying why one would resolve it in the way which Aeden was suggesting it ought to be resolved. So it's plainly just come to the view that if you establish the time frame is as suggested, then that's it.
Yes.
That's the sole reasoning.
In that single sentence. When, as I've sought to demonstrate, that is clearly an inappropriate, wholly inappropriate conclusion on the evidence as it stood, but also actually on the evidence recorded by the judge within his judgment. He makes it very clear that there are all these issues, and then says, I'm not going to resolve them. But even if the court resolves against us, so far as question A, should he have succeeded on, if he succeeded on the timing argument, was that the cause of the claimant's intrapartum PHI. On the judge's finding, clearly not. If, on the other hand, the court considers that the Court of Appeal was correct in deciding that causation was intrapartum, in that sentence to which I've made reference, where does that take one? Did the trial judge make a finding of breach of duty against the clinic to which a finding of causation could attach. My learned friend dealt with this, and it's dealt with very extensively in the written cases. I don't take you back to it, but in paragraph 75 of the judgment judge records effectively three failures: failure to record Aeden's discharge, limited record of his condition after birth, sorry, four failures I should have said, no reason being provided for the discharge, and fourthly, and the only relevant one, because it's the only antenatal event, no monitoring of his heart rate between 2000 and 0030. Well, of course, even on the Aeden's case, there's no causation in relation to that, because their case is that the whole of this hypoxic event occurred at the very end of labour, just before delivery. There was no finding of a breach of duty in respect of a failure to monitor Aeden's heart rate in the period when Dr. Abdulla was also present at the clinic. And there was a clear issue on the pleadings as to the extent of the clinic's duty whilst Dr. Abdulla was present and responsible for monitoring. We've not looked at it, and it may be worth going to page 345. This is within the re-amended defence of the first defendant. It's 345, subparagraph D on that page, 16D. The first defendant avers that its staff maintained proper monitoring of the claimant prior to the arrival of the second defendant, who in turn took over monitoring from his arrival up to delivery, as there can be no fetal monitoring after birth. So there's a clear issue raised on the pleadings, who, as between the obstetrician, if I can call Dr. Abdulla that, and the clinic, is responsible for monitoring when the obstetrician is actually present. There's no finding. There was no further finding as to what a proper or complete record would be, specifically whether this included fetal heart rate monitoring and whether any such duty was modified when Dr. Abdulla was present. And interestingly, and again, it may be of assistance to go to it, if I could take you to page 2319, to paragraph 19, it would appear that Aeden and his representatives accept that there was a lacuna in this regard.
Sorry, what is this document?
This is the submissions of the, I'm so sorry, it's the amended notice of appeal to the Court of Appeal. I should have made that clear.
And so it's paragraph 19.
Paragraph 19, my Lord, yes. The learned judge erred in his equivocation over whether the first respondent did not have a duty to monitor the FHR of the appellant. His finding the midwife fell short of her expected duty by not recording certain aspects of the condition and status that claimed his mother, and that this, quote, failure to record could only have caused damage if it, without having recognised, could have caught something, close quote, is implicit in its interpretation that the first respondent did have a duty to monitor. As such, this should have been explicit in the learned judge's finding of breach of duty as it related to the first respondent. So not only do we submit that there is no relevant finding of a breach of duty in terms of monitoring in the second stage just before delivery, but it appears to be common ground that there is no specific finding to that effect, albeit that the learned friend seeks to argue, oh, well, it must be implicit. And of course, there is evidence that there was monitoring in the relevant period. I don't take you back to it, but it's the critical note of Dr. Abdulla 530, where he describes the FHR as regular. My Lord, Lady, I would again respectfully submit that I know my Lord Stevens is unpersuaded.
What?
That the Dr. Abdullah should be, the evidence of Dr. Abdullah as to what that note means should carry some weight, albeit that, of course, I understand the judge's reservations about his recollection. So it follows, we respectfully submit from all that, that even if the conclusion is reached that it was 4 to 5, even if the conclusion is reached that damage occurs during the 4 to 5 period, still there is no finding that there is a relevant breach of duty found by the judge against my clients, the clinic. And that follows even if the conclusion should have been reached that there were fetal heart rate abnormalities, because of the point I've adverted to in relation to where the responsibilities lay. And lastly, Lords, Lady, and I accept this is not our strongest point, but it nonetheless remains valid, even if it's concluded that intrapartum PPHI was the cause of the injury, 2, that there were fetal heart rate abnormalities, and 3, it was the clinic's responsibility to detect them, none of which I accept, it would still need to be proved that Dr. Abdullah would have accepted any such report and then achieved a caesarean section delivery in time to avoid damage. As I've said, we accept it's not our strongest point, but the critical point is that, of course, these are all issues in the chain of causation. And there are no findings. Turn, if I may, to the last topic under this.
So the proposition you're advancing is, well, at the moment I don't have a clear idea as how many midwives were there. I rather suspect only one. Is that right?
I think the impression to be gained from the evidence of Dr. Abdullah was 1, and the writing is the same, as the court will have observed. The writing of the various midwifery observations is the same, so that would appear to be 1.
And the midwife was employed by your client?
Yes.
Right. And so you're saying that the fetal heart rate abnormality was solely the responsibility of Dr. Dr. Abdullah?
Yes.
Right. Well, that's quite to my mind, an unusual proposition to be putting forward. But anyway, be that as it may, there is no findings about it. I accept that.
Yes.
But it's somewhat unusual for a midwife to say, I exonerate myself. It's entirely the responsibility of the doctor.
Well, we go back to the difficulty with Dr. Abdullah's evidence, but as the court has seen, and as I said yesterday, Dr. Abdullah was saying, well, I was monitoring the fetal heart rate because I could hear it and I could see it. The question then, of course, is, does that exonerate the midwife, or does the midwife retain a responsibility herself to say, Dr. Abdullah, you've got this all wrong. This heart's decelerating, or it's bradycardic or tachycardic, whichever it may be. Or whether the midwife is entitled to say, well,
the answer to that question is fairly straightforward. But anyway, be that as it may.
But as your lordship has the point, on any, whether right or wrong, there is no finding. Lastly, in relation to causation,
and I suppose, in a way, the judge should have been assisted with grappling with these issues, and by them being properly defined because the overriding objective does require counsel to assist the court in relation to addressing the issues. But anyway.
Well, I won't take you to our submissions to the judge. I like to think that we had dealt with all these issues before the judge, but of course...
No, I'm not suggesting otherwise.
Because the judge adopted the route that he did and said, well, if it's 4:30 to 5, it needs to be 4 to 5, or there is a barrier to recovery, effectively. if he stopped short at that point and said, well, I don't think it's 4 to 5, I think it's 4:30 to 5:30, then of course the judge did not need to go on to consider all these difficult issues of causation and responsibility and negligence and so on and so forth, as I've already indicated. Submitted. May I turn lastly to this question? If no such findings of causation or causative breach were established, did the clinic nonetheless conduct the litigation in such a way that it should not now be permitted to rely on the absence of such findings? For shorthand, we've just called it a sort of Henderson and Henderson point, if I can put it like that. My Lord, the importance of this is, we respectfully demonstrated by Aeden's reply to the written case of Dr. Abdulla, which one sees at page 2803, para 63. We accept that Aeden would lose if there was not enough time, that is, on a 4:30 timing, for the injuring duration of PPHI to have been sufficient to cause permanent injury intra partem.
I'm terribly sorry, I haven't got the page.
I'm so sorry. 2803, my Lord.
2803, thank you.
This is, we respectfully submit an important paragraph. Yeah. So, in other words, the timing point, and that's the concession.
This document is?
This is the reply before the Judicial Committee. It's the reply of Aeden to the written case of Dr. Abdulla. So that's the timing point, of course. Then we also accept that sufficient time for the injury is not the same as proof that the injury probably occurred intra partem. That we submit as a very important sentence. In other words, we accept, presumably, that there is this raging dispute on even if the question of even if the timing issue is resolved in the claimant's favour, Aeden's favour, where does that take you? Does it take you to a conclusion that the damage occurred in that period, or presumably to negligence? Well, I'm sorry, ignore that last part. It doesn't take you to a conclusion that injury probably occurred intra partem. And then this, and this is the Henderson point. However, the case was litigated on the footing that the timing dispute was dispositive both ways. And Dr. Powers yesterday appeared to us, at least, to start by saying, well, there was an agreement between counsel that it was dispositive, so that it's not open to either Dr. Abdulla or the clinic to argue that even if the timing issue is resolved against us, there is still no finding that the injury occurred during the intrapartum period or in relation to causation. But if that's right, it is, we respectfully submit, remarkable that that point was not argued before the Court of Appeal. It's quite clear, as I shall seek to demonstrate in a moment, that all these arguments were before the Court of Appeal. And if the Henderson point were to be run on the basis, well, you can't argue that, you've agreed it, then it should have been stated and stated clearly. It would no doubt have been recorded by the Court of Appeal, and according to my recollection, it certainly wasn't. Sorry, I should not be giving evidence.
It would also be inconsistent with the judge's paragraph 147.
Yes. Because if the concession was made, it must have been made before judgment, presumably. It's certainly not made in any of the submissions. And the judge would therefore not have been troubled by all the causation issues. And one would have anticipated, would have said, well, there are all these raging issues which he discusses, Wilkerson's evidence and so on and so forth within the judgment. But fortunately, I don't need to consider all that because it's all been decided, all been agreed. No such reference. Dr. Powers, against me, but also, of course, against Dr. Abdulla, seeks to indicate that Mr. Ram Logan's submissions in the Court of Appeal effectively concede the point. Lord, this is based upon page 2496, 2498. But the critical issue we respectfully submit is whatever submissions may be made in relation to those paragraphs, which at best we submit are equivocal, the position becomes entirely clear when we come to 2496, paragraph 11, and as my Lord Doherty pointed out yesterday, the executive summary. 2498.
Yes.
The issue therefore arose for the court to make a finding of fact as to whether Dr. Abdulla arrived at private hospital 4:30. This extremely complex and convoluted matter, riddled with expert evidence, essentially hinged on this one finding of fact before causation could be explored further. It's quite clear that those submissions are not conceding causation. And then the executive summary at the bottom. The parties agreed that the court had to determine if Dr. Abdulla at 4 or 4:30 as a precondition to determining if it was possible that the cause of Aeden's condition was due to negligence or not. So, on its face, we respectfully submit that one can see that there is no concession within Dr. Abdullah's arguments before the Court of Appeal, such as that for which the learned friend for the claimant contends. As against us, in his reply to the claimant's written case, at paragraph 21, page 2864, paragraph 21. I don't think perhaps I needn't take you to that. Surgi-Med relied upon Dr. Wilkinson's evidence to support its contention that the injury occurred prior to labour. That's right. Secondly, at paragraph 24, Surgi-Med's present suggestion that these matters, the mechanism of injury, remained unresolved is therefore inconsistent with the structure of the judgment itself. We don't accept that, and I refer again to paragraph 147 at the risk of wearying the board. But importantly, at paragraph 25, against that background, page 2866, Surgi-Med did not identify before the Court of Appeal any clear alternative appellate route if the 4 o'clock chronology were restored. It did not invite the court to remit the matter, nor did it specify what further findings on detection, intervention, or avoidability were said to be required before liability could be determined. Its case remained directed principally to upholding the trial judge's 0430 chronology and the consequent conclusion that the injury occurred before labour. So there you have it. It is said that we were not making any submissions beyond, no, not 4 to 5, but 4:30 to 5:30, and we were effectively, it is said, conceding that if that finding goes against us, then causation and causative breach are established. And as I hope to demonstrate in a moment, those propositions are palpably false. First of all, if I could take you to 2395, which is the Court of Appeal submissions, our Court of Appeal submissions.
I'm sorry, 2395?
2395.
Yes, and you said that is?
Those are our Court of Appeal submissions.
Right.
And this is the paragraph 1.3.2 at the bottom of that page. Even if the judge should have found that the second respondent arrived at 4 o'clock, the balance of the evidence did not justify a conclusion that the appellant's injuries were caused by at least an hour of damaging PPHI during the period before his labour. So the issue is clearly there stated. And then over the page, 133, even if the appellant's causation case could be established, there is no causal nexus between the first respondent's breaches of duty, which were found by the judge, and the damage to justify a finding of liability against the first respondent. And then at 1.3.4, there were no other grounds upon which the judge could have found causative breaches against the first respondent. So, in different words, of course, but we respectfully submit precisely the arguments that we seek to make before the board in this case. In addition, and the speaking note, I'm sorry, I should just have finished, I'm so sorry. The same document, 2421. Just above paragraph 5, again, the first respondent does not accept the appropriateness of this finding. That's the, but again, this finding of breach of duty, that's the 8 o'clock in the evening, 12 o'clock in the morning finding. But again, in the light of the absence of causal relevance, will not address the issue further. In the speaking note, I think it suggested that none of this was raised in the Court of Appeal. Well, one can see that it was raised on behalf of Dr. Abdulla. That is within the Court of Appeal's judgment at paragraph 98. The issue therefore arose for the court to make a finding of facts as to whether Abdulla arrived at Surgi-Med at 4 or 4:30. Mr. Ram Logan contended that this matter essentially hinged on this one finding of fact before causation could be explored further. So it's quite clear that it was ventilated by Dr. Abdulla before the Court of Appeal, and apparently he was not stopped. But in addition, in our speaking note from the Court of Appeal, and as the Court will recall, that is in the supplementary bundle 2, pages 15, 16 being the relevant parts, 15, 16 of that bundle. 16, 17, my memory plays before. And 6.5, in discussion in the written submissions of the first respondent and the written submissions of the second respondent, there was a very substantial dispute as to whether the damage could have been caused in the relevant hour at all. There is no finding that the injury was caused by this PPHI. And then over the page, at the top, accordingly, if the appeal succeeds on issues 1, 2, and 3, and those are identified at the outset of this document, the ones I've been dealing with, it will be necessary either for this court to determine this issue or for there to be a retrial of this issue. Lord, the point is made that there should have been some sort of notice appealing the judge's, if I can call it this, non-finding of causation. That suggestion is dealt with also within this document.
Well, you weren't challenging any finding which the judge had made. Why would you cross-appeal?
I was coming to that. There's nothing to appeal. The judge made no findings in relation to this issue. I'm sorry, paragraph 147 again. It's quite clear. He did not make any of these findings. He did not make any of these concessions. So that falls away. The judge didn't make any findings, so there's nothing to appeal, as I put it.
Can I just ask a question relating to this paragraph about practice in Trinidad and Tobago? Courts within the UK may differ on this. Is it customary for a Court of Appeal in this situation, if it has the full transcript of evidence, to sort of roll up its sleeves and decide these matters of new, or is it normal practice to send it back for a retrial?
Well, I think the short answer to your question, my lady, is it could be either.
It depends on the case, so there's no
I think it
established practice. Okay.
depends on the court, and presumably it depends on the difficulty of the resolution on paper, if I can put it like that.
So that's why you give the alternative.
Yes, and that's why we were saying that you need... The difficulty here, we submit, is the judge has recited the evidence. He's recited Dr. Wilkerson, he's recited Dr. Sinkhorn, he's recited Dr. Milligan, and others. But he's made no findings. So that the submission we made was, well, you, Court of Appeal, if you want to, can try and just determine this on the transcripts, presumably it would have to be, and the reports, of course. Or, because there need to be findings in all these areas, findings of fact as to which evidence, expert evidence you prefer on which topics, and the only finding was, as you remember, that the judge held that he was less impressed by Dr. Jayasimi than he was by the other expert. There are no other findings in relation to reliability of expert evidence at all. So we were saying, well, someone's got to determine it, because this issue remains live, even if you reverse the temporal, the timing finding, and either it's got to be dealt with by you, Court of Appeal, or it's going to have to be remitted for a retrial of these issues.
One would imagine that if the Court of Appeal were going to resolve factual issues on the papers, which would be an unusual experience for us in this jurisdiction, that there would be extensive and exhausting submissions uphill and down dale on the reports and also the transcripts. But that didn't happen before the Court of Appeal, as I understand it.
No, certainly not in the detail that would have been necessary for the claimant to say, you've got to... He was saying, if you resolve the timing issue in our favour, causation follows, as I submitted. And they said, well, all right, we'll accept that. That's what we've done in our sentence. We were saying, no. If you're going, causation was not resolved by the judge, 147, I'm sorry to come back to it, but therefore, if causation is to be resolved, it's either got to be resolved by you, or it's got to be remitted. And certainly the Court of Appeal were not saying, well, all right, we'll deal with it. So the result, the answer to your Lordship's question is, no, there was no such forensic examination over days as would be necessary of the whole of the reports, the whole of the transcripts, to consider what the correct answer to that question might be on the papers. And indeed, certainly my understanding, and I'll be corrected if I'm wrong, is that it would be very unusual, even in Trinidad and Tobago, for such a forensic exercise to be conducted by the Court of Appeal in the absence of the opportunity of hearing from the experts themselves. So it's suggested, I think, that I didn't make these submissions in the Court of Appeal. Well, my recollection, and I'm sorry to give evidence, but supported to a large extent by my instructing attorneys, is that, as you would expect, I used my speaking note and I went through it in the Court of Appeal. We can see that Dr. Abdulla made these submissions. It's recorded by the Court of Appeal. We can't see that I made them because it's not recorded by the Court of Appeal. But it would be very surprising, we respectfully submit, if Dr. Abdulla had made the submissions, and we have documents prepared in which all those submissions are set out, but we did not follow suit. I'm very conscious of the fact we're coming very much to the end of time.
Yes.
Lastly, last question, if the Court of Appeal was correct to find Dr. Abdulla liable, should that finding also apply to a clinic? The Court of Appeal appears to have made a new finding of breach of duty against Dr. Abdulla. It's the general mismanagement of labour point. The basis of that finding is not really a matter for me, but with respect, I find it difficult to perceive how that was arrived at. They specifically declined to make any such finding against me. Now, there is no corresponding finding in relation to failure to monitor the fetus in the 5 o'clock to 6:15 point. So that would need to be determined. I'm repeating myself to some extent, I fully appreciate. But the learned friend says, well, it simply follows as night follows days. If Abdullah's liable, so is the clinic. Well, we respectfully submit that does not follow. And I repeat the point that there are issues, I appreciate my Lord Stephen's comments, as to responsibility for monitoring. But also, there are issues, as I've already submitted, on the chain of causation. What would have happened if the midwife had said, look, Dr. Abdulla, you've got this all wrong. This baby's in distress. You need to do something about it. Would he have done something about it? Would he have delivered the baby in time? And critically, would that earlier delivery have avoided all damage? A very contentious issue in many of these cases, the all will know. Or if he'd been delivered, say, at 6 rather than 6:15, would he have suffered some, and if so, what damage? And that issue, of course, has a very major bearing on the quantification of the claim. Because if the claimant would probably have suffered some, albeit more minor disability with earlier delivery, but not as severe as the delivery now, what, if any, care would he have needed? Would he have been able to work, and so on? So there are various sub-issues there, all of which would need to be determined in concluding whether the clinic's liability follows that of Dr. Abdulla. Well, that's the final issue that's raised in the issue facts and issues before the board, unless I can assist further.
Can I just ask?
Yes, one question from Marwan.
So far as disposal is concerned, you're asking us to dismiss Aeden's appeal against you. You have a cross appeal. Yes. Will you be required to deal with that too, or not?
Well, my Lord, this case is bedeviled with pleading points.
Yes.
We are submitting that this court should reverse the judge's finding of fact in relation to the timing and accordingly dismiss the appeal. It seemed to us that there was at least the scintilla of an argument that unless we put in a cross appeal on that point as to whether or not the Court of Appeal's conclusion on timing should be reversed, it might be argued against us that we should have put in that notice and therefore we weren't entitled to argue it. So as a matter of probably extreme precaution, we thought it appropriate to launch a cross appeal just on that point, saying we're seeking the reversal of the finding of fact in the Court of Appeal and the restoration of the judge's finding.
So it would be sufficient simply to dismiss the appeal?
If the board were to conclude that the finding of the judge should be restored, that is sufficient to deal with the cross appeal. I'm grateful.
Thank you, Mr. Brown. We're very grateful to you. Mr. Strain.
My Lord, thank you. The first point I'd deal with quickly. Dr. Powers yesterday felt it necessary to dispel the idea that overdose of misoprostol was the only allegation of negligence.
Sorry,
Could
you're
you
going to have to speak up a little bit.
You definitely dropped your...
I was getting some feedback from one of the speakers, which was making me lower my voice. Yes, I was saying that Dr. Powers yesterday felt it necessary to dispel the idea that the overdose of misoprostol was the only pleaded allegation of negligence, and I apologize to him if I gave the impression I was making that submission. The point I was trying to make, it was the only finding of negligence made by the trial judge. And the Court of Appeal introduced a new finding mismanagement of delivery, which, as it happens, was not actually a pleaded particular of negligence, on the erroneous understanding that the parties were agreed that 90 minutes of active attempts amounted to mismanagement of delivery, which was simply a misunderstanding of the position below. But that leads on to a question arising from Dr. Power's concession yesterday that the excess dose of misoprostol could not have caused Aeden's injury, which results, it appears, in Aeden's case depending on the board making a new finding of an alternative breach of duty. But it has not, in my submission, been set out what finding of breach is open to the board. I suppose, conceivably, if it appeared to the board that some finding of breach would inevitably follow from the judge's findings of fact, then it might be open to the board to say so. But that has not, in my submission, been set out, what finding or why. So I say no more about that. We filed with the board this morning part 1 of the CPR in Trinidad, the overriding objective, really by way of answer to my Lord Stevens' question yesterday: is there an interpretation provision under the overriding objective?
It's not that ironic, yes.
It doesn't, of course, help me to escape the restrictive policy of the CPR in Trinidad when it comes to amendments. That's pretty clear. But I do say...
They were invited 16 years ago to consider amending their provision, and so far they've politely declined to do so.
They ameliorated it somewhat in response to CBLAC.
Right.
Because before there was...
There was amendment in 2016.
Yes. Yes, which allows there to... Previously, there couldn't be an amendment after the
and so
CMC.
Exactly what... Does that have any... Well, does that assist your client?
No.
That amendment?
No. But I say it does that restrictive approach does not lead to the conclusion proposed by Dr. Powers that a trial judge in Trinidad cannot hear evidence deviating from pleadings. I maintain the general proposition that I advanced yesterday, that is within the powers of the trial judge. Perhaps the judge's room for manoeuvre might be narrower in Trinidad in light of that restrictive policy.
Certainly seemed an extraordinary proposition that even though there was no prejudice and all the interests of justice pointed one way, if the pleadings pointed another, they must prevail.
Yes, I would agree that's an extraordinary proposition. But of course, if the judge is considering hearing evidence deviating from pleadings, we can expect the judge will bear in mind the restrictive policy with respect to amendments in Trinidad and Tobago. But I say it doesn't follow from that restrictive policy that deviation is always forbidden without amendment. And the question raises the general question: does every deviation require an amendment of a statement of case? And it raises the particular question, of course, does this deviation, in this case, require amendment of the statement of case? And considering those questions, in addition to questions of the justice of the case and prejudice, the judge might also bear in mind the purpose of pleadings, generally, including the question of what is essential and necessary to plead and what is not. And in this case, the purpose of these pleadings in this case. And those thoughts occur to me derive from the approach of the Court of Appeal in Phones for You, to which the board was referred yesterday. But we can look at it in a bit more detail. The case begins at 2984. I've just lost my screen. Maybe I can just take a look at yours. 2984. Sorry, my laptop's gone dark. But
You've given us the right page.
yes, that's the.
Sorry you can't see it.
And the discussion begins at 3023, and it's ground 3. Thank you. So that's ground 3, and this concerns the new case theory. What happened was the judge had rejected part of the claimant's case as not probable on the basis, I've got it, on the basis that there were other more plausible possibilities, and in particular a theory that had not been canvassed at trial. But in discussing the alternative, the new case theory, we can see the Court of Appeal going through the law, including some of the cases we looked at yesterday. But I want to pick it up at paragraph 193. This is Lady Justice Falk's discussion and drawing the threads together. So perhaps 193, 194, and 195. So one of the things your lordships and your ladyship will see that in her discussion, Lady Justice Falk makes a distinction between evidence not essential to the pleading and pleaded issues, which she defines as facts necessary to establish a claim or a defence. Although you can see at paragraph 195, she holds that there's no bright line between them for these purposes, for the purposes of allowing deviation from pleadings or advancing theories not pleaded. And then at paragraph 198, you can see her applying that distinction to the facts of the present case. So there is a relevant distinction for these purposes, between pleadings which are essential to the cause of action or to the defence and pleadings which are evidence. But of course, if an evidential issue becomes important and it would be prejudicial to change the case, then it's going to be further along the spectrum. Now, I appreciate that these principles are elucidated in the context of the English CPR, but they're capable, I would submit, of informing the answer to the questions in Trinidad and Tobago. Must one amend in this case? And can one deviate from unamended pleadings in this case? So I'll just point to those principles to assist your lordships and your ladyship with the question, which I would the question whether the judge was entitled to hear the evidence in this case, and I say that he was, and he made a decision within the range of decisions that were open to him on that question. Of course, the point's been made already. I won't make it again. That the cases relied upon by Dr. Powers are further along the spectrum than our case here today.
Another potential way of looking at it is interpreting what your statement of case was. You have regard to the defence of the clinic, and that it would be absurd to apply an interpretive approach to your defence that would lead to a different conclusion, so that Dr. Abdullah would be arriving at 4 o'clock and at 4:30, depending upon.
Yes.
I mean,
Well, indeed, my lord.
That interpretive approach was in fact canvassed in Gulf View, and it didn't run there. It was paragraph 59, page 2950. It didn't run there because it was a joint defence being put on.
Yes.
There weren't two defences, and it was perfectly. It wasn't absurd in that case the one could not construe interpret the defence relying on the principle of absurdity, because it wasn't absurd for the parties to join together in the defence that they were making. So the principle of absurdity has been relied upon, and it is an interpretive tool.
Yes, my lord. I suppose it's because of the ambiguous nature of Dr. Abdullah's defence, and because of the different position
Lord
taken.
Burnett said, which part of the defence are we going to hold you to?
Yes. So this is a case where the restrictive nature of CPR Part 20 doesn't bite. The principles I sought to elucidate might assist where it does bite. So might assist in guidance on the difference between being required to amend and being allowed to deviate from unamended pleadings.
And I don't want to take up too much time, but in relation to the amendment that wasn't permitted by the Court of Appeal, there was in fact a way around that by somebody else making the application to amend.
Yes,
that avoided people having to advance a case that they knew was patently wrong, because the initial case was the CT scan did not show any brain injury, and that was wrong, and it would be extraordinary for expert witnesses and for counsel to put forward a case on the basis that something was wrong. And,
that came about because of a cooperative attitude between the parties. It's somewhere because of a cooperative approach between the parties.
Yeah.
Somewhere between my learned friend's re-amendment and my predecessor's failure to re-amend that cooperative approach.
It would also put witnesses in an impossible position, having taken the oath they take, and especially experts in an impossible position who are obliged to set out everything that's material. I mean, they sign declarations to that effect. So, like Lord Stevens, I respectfully find the decision of the Court of Appeal on that issue a little surprising, but happily, as you say, the parties approached it on a sensible basis so that the court was not misled and the experts were not put in an extraordinary position.
It might well have been, as my Lord Stevens suggested, that the circumstances there could have fallen within a more liberal definition of a good explanation. But whether
that was rejected.
The promptitude question may have been failed in any event. With respect to objections, I mentioned yesterday that there was a round of evidential objections which wasn't included in the bundle, but there are references in the chronology to it, and indeed in the transcripts. So just to make good the point I made yesterday, the procedural chronology is at 2741. And at the bottom of that page, you can see reference to the claimant's evidential objections being made in December 2016. And then over the page, the second and first defendant's evidential objections being made in April and May 2017. And what appears from the transcript is that actually evidential objections were still being, the judge was still ruling on them piecemeal at trial. And one can see that. Just a few examples are 1224, there are reference to evidential objections. So line 15, 16.
Sorry, page?
Page 1224.
Thank you.
So you can see at line 15 and 16, there's just some examples that come up. So I'm informed by Mr. Takla Singh that the common practice is to rule on them just before the witness comes to the box in Trinidad. And then, so I probably don't need to give your lordships further examples, but I would show you, your lordships and your ladyship, page 1590.
There was no evidential objection taken by anyone to your client giving evidence as to timing, is that right?
Well, we can see a discussion of that at 1595, because this is one of the points at which Dr. Powers interrupts cross-examination of one of the claimant's witnesses, cross-examination by Miss O'Rourke, on the basis of a 4:30 to 5:30 timing. And then Ms. O'Rourke objects, and then there's a discussion at the very bottom of the page, beginning at line 28, as Ms. O'Rourke's saying, well, they put in other evidential objections, and the court says, I don't recall seeing that objection.
Sorry, you're at the foot of 1595?
1595 begins at line 28.
Thank you.
So I understand the judge to be saying, I've seen many objections to Dr. Abdullah's statement, but I don't think I saw one to the timing being 4:30 to 5:30. And Dr. Abdullah's counsel says, my lord, you didn't rule it out. The court says, I didn't rule it out. Yes, so. And then, whereas she goes on to say, in other words, it wasn't accepted in evidential objection. Not clear whether one person saying the judge rejected such objection or whether the other is saying no such objection was made. But that's, if you like, that's the clearest we get. That's the reference to the question of evidential objections in relation to this particular piece of evidence.
Who's the witness at this point? I'm sorry.
The witness at this point was one of the claimant's experts, I believe.
Okay.
Sorry, I'll have to go back up. Sorry. Mr. Jaisimi.
When your client gave evidence, just before he gave evidence, was there any objection to his evidence being given? Because apparently, according to the practice and procedure in Trinidad and Tobago, the objections are taken just before the witness gives evidence. That was the opportunity for Mr. Powers to say, I object.
The beginning of Dr. Abdullah's evidence is 091.
Sorry, page?
2091.
2091.
Thank you.
So there isn't.
There's just one more point I wish to cover. That's Dr. Powers yesterday drew attention to a part of his reply, identifying the timing issue. And I just thought I should show that to the board in its full context, because the pleading in the particulars of claim is to be found at page 236, and its particular Roman 12 failing to determine at an appropriate time that caesarean section was indicated. And the amended defense pleads to that at page 292. Paragraph 3418. So denying paragraph 12, it was performed because of failure to progress. There was no delay in delivery. So the no delay in delivery is then picked up in the reply at page 319. And this is the paragraph Dr. Powers took you to. (26.1). So that's the context in which that issue of timing is picked out by the reply. So I do accept they're picking out the difference there. But the issue is one as to whether there was a negligent failure to proceed to caesarean section. It's not the decisive issue that became defined at trial.
A negligent failure in terms of a delay in proceeding to... Sorry, you said a negligent failure...
A negligent failure to proceed promptly to caesarean section, or to fail to appreciate the need for caesarean section. That's
it
pleading
fits into
well.
timing because we have the note about it having to be an immediate section.
Yes. So that's the point made at paragraph 26 of the reply there, yes.
I wonder, Mr. Strang, it's my fault entirely, but could you just give me the paragraph number in the amended defence where it's denied that there was a delay in delivery? I didn't...
3418.
3418, thank you. I didn't get that down.
The page for that was 292.
Yes, I've got it, thank you.
That was all I wanted to say by way of reply, unless the board has any further questions.
Anything further? Thank you, Mr. Strang. We're very grateful. Mr. Powers.
My Lords, my Lady, 5 points in reply to the clinic. First, as far as Dr. Aguilar's statement, a referral letter is concerned, I remind your Lordships that this was served pursuant to a hearsay notice to which no objection was made. His evidence, therefore, became evidence of the truth of the contents, including the truth of him believing or saying that there was a prolonged second stage. Now, we have explored the issue of second stage and active stage. We know from the evidence that so far as a primip is concerned, which Mrs. Balwah was, it's 3 hours, the first hour of which is passive, and the second hour, the remaining 2 hours, are active. And it becomes a prolonged second stage if that exceeds 2 hours. And if I take you, if I may, to the submissions of Dr. Abdulla on this, at page 2763, paragraph 10, you will see in this case his meaning in paragraph 10, 1 hour period of attempted vaginal delivery was also described as the second stage, or the active second stage of labour. So we can take from that whenever the attempted period was, that marked the beginning of the clock, so to speak, in respect of prolonged second stage. And of course, we know that that depends upon a number of factors coming together, whether that started at 4 or whether it started at 4:30. If it started at 4, it was prolonged second stage on Dr. Abdullah's own evidence there, and that was the conclusion which had been reached by Dr. Aguilar. The second point that arises is, should Dr. Abdullah be entitled, despite his lack of recollection, to interpret his own note? We would agree that insofar as he's trying to interpret his own note, that would be perfectly permissible for him to do so. It would seem nonsensical if he were not to be able to try and interpret his own note. But, of course, his own note in his interpretation conflicts with, first, his pleading in paragraph 34.23, when he says that he was called when Mrs. Balwah was fully dilated, and yet, in his statement, at paragraph 36, he says full dilatation wasn't until 4:30. And on his own account, the call, at least, was made at 4 o'clock. So despite his efforts, so to speak, being admissible as to the interpretation of his own note, he's interpreted in two different ways. Thirdly, the recital of the strength of Dr. Abdullah's evidence is, by my learned friend, Mr. Brown, seemed to me, in listening to it, to be extremely persuasive, that the Dr. Wilkinson and Dr. Sinkhorn evidence overwhelmed by any sensible consideration the evidence advanced in respect of causation, medical causation, by Aeden. The difficulty with that submission is, first, of course, it's a submission on primary fact, but more particularly, the difficulty he faces in our submission is that if that is the case, and I ask it rhetorically, why on earth did the judge not determine causation there and then on such obviously, as Mr. Brown would say, obviously superior evidence on causation? Why did the judge not do that? Because had the judge done it, had he decided it in Aeden's favor, Aeden would have won. Had he decided it in the defendant's favor, he would have lost. That would have been an end to it. It would have been such a simple solution. But the judge appeared to go down, on the face of it, a rather strange pathway, which he must have known would lead to an appeal, which was, because it was apparent before him, that there was an argument on the pleadings. And yet, nevertheless, he chose to go down that pathway, knowing that this issue would inevitably be appealed by the claimant to the Court of Appeal, as indeed, of course, it was. And inevitably, the issue of the counterfactual would arise if there were to be a counterfactual, namely that a residual issue of causation, which he didn't determine. It's a submission which I accept appears to be persuasive by Mr. Brown, that there was no failure, no finding of failure against his client, the clinic, in respect of monitoring after Dr. Abdullah's arrival. In other words, no finding of breach by the judge in respect of what we should call the second stage, as we have throughout. The neutral position would be that the allegations were made and they weren't addressed by the judge. And we've had a look at paragraph 131 of the judgment, which you will find on page 75. But although that appears to be neutral, and therefore not an issue which was in any sense decided by the judge, which would effectively mean that even if we establish everything else against the clinic, we are left with a situation where we didn't establish that there was a breach in respect of the second stage. Now, that looks to be an attractive and effectively infallible defence. But in our submission, my lords, my lady, if you look for a moment at the judge's judgment 146, which you'll find at page 82, there is what appears to be a cryptic interpretation of what's happening in the judge's mind. It's a short paragraph. It reads, both parties agree that if this is the case, then the event which caused the claimant's condition could not have occurred during the intrapartum period. Now, it's obviously from 4 o'clock or 4:30 onwards, and therefore could not have been caused by the breach of duty of care by the first, the clinic, and the second named defendants. That, in our submission, must be read as a finding by the court, although not obviously explicit, that there was a breach of that duty which the court found and wasn't appealed, of the duty to record between admission and discharge, and it applied to the intrapartum period. So in our submission, firstly attractive in respect of paragraph 131, the answer is to be found in 146, and that it did cover that period. Fifthly, the paragraphs which I'm sure, my lords, my lady, you will reflect upon again because they've often been referred to in Dr. Abdullah's submissions to the Court of Appeal, and you were taken to paragraph 11 at page 2498. I suggest that there is a different interpretation to be placed upon this than that which Mr. Brown has sought to persuade you is the case. If I may, I read it. The issue therefore arose for the court to make a finding of fact as to whether Dr. Abdullah arrived at the private hospital at 4 a.m. or 4:30 a.m. This extremely complex and convoluted matter, riddled with expert evidence, essentially hinged on this one finding of fact before causation could be explored further, that Mr. Brown relies upon. It goes on in these submissions to say this is commonplace in matters such as these, as the pathophysiology of CP is elusive and remains mostly unascertainable. But timing, fetal heart rate monitoring, and fetal distress remain the cornerstones of the fact-finding exercise. It's a recognition that, as the judge in our submission recognized and didn't simply find Dr. Wilkinson's team or Dr. Milligan's team, Aeden's team, win on the argument of medical causation, it's a recognition of the complexities that arose in the medical causation evidence, which could only be resolved by an issue of timing. And lastly, in respect to Mr. Strang, if I may, and the overriding objective, which you have in the third supplemental bundle and you've been looking at this morning, you will see in respect of paragraph 1.2, I should say rule 1.2, the circumstances in which this becomes applicable. The court must seek to give effect to the overriding objective when it, 1, exercises any discretion given to it by the rules, or 2, interprets the meaning of any rule. That means when it comes to looking at the threshold criteria in Rule 20.13, if those threshold criteria of reasonable explanation and promptitude is a clear statement of the rule, the overriding objective does not apply. It does, of course, very much apply to what became subsequent to the Bernard and Silac case, the change in the rule, adding the discretionary elements to be found in paragraph 3A. So the short submission on the overriding objective is that it doesn't bite upon the principal and clear issues of threshold. There is no authority to suggest that it does. But you accept it bites on the second part, provided, of course, the applicant applying all the time for an amendment can overcome the first two threshold problems. A few general points, if I may. The issue about whether or not the cause of the problem of the hypoxic ischemia doesn't really appear to have emerged here. Throughout all of the evidence, the issue has been directed at it being prolonged partial hypoxic ischemia. And that's the whole concept between the 60 minutes plus that would be required. It's included within the submissions. It was accepted by Dr. Wilkinson in his evidence. In particular, I'll refer you to the lines of it, if I may, but not read them. Page 1862, line 31, through to 1863, line 20. The acceptance being that the injury was hypoxia ischemia, and that the real issue, not the nature of the injury or the mechanics of the injury or what was the cause of the PPHI, it was hypoxia ischemia which caused this injury to Aeden. But the issue, as he accepted, was whether it was prepartum or antepartum. A short point. Yesterday, Lady Wise asked a question which I was unable to answer on my feet at the time. When the critical timing issue first identified before the court, it was raised again today. In our submission, this is clear from the judge's judgment, which you'll see on page 36 at paragraph 14. Sorry. With respect to the timing of events, given the reports of the experts, it was agreed that if the claimant was in respiratory distress from 4:30, defendants allege, then that could not be the event which caused his injury. The attorney at law for the second defendant put to Shelly-Ann throughout her cross-examination that for this reason she moved the occurrence of events a half an hour earlier, a water bag breaking at 3 a.m. instead of 3:30 a.m., and the second defendant arriving at 4 and not 4:30 a.m. Shelly-Ann vehemently denied this, insisting that she recalled the times of the events and that they were accurately contained in her pleadings and witness statement. And you'll remember that from my submissions to you yesterday, that when looking at the second defendant's expert's evidence in his report, he had referred to those timings himself In other words, on his analysis of the medical records. And there can't be any question at all that the timings were generated artificially. These were the recollections of the claimant, and the suggestion that she had fabricated them in order to advantage her case. Actually, it gives a number of interesting aspects to it, because there is implicit within it a suggestion that if the timings are indeed as she says, which were admitted, then it does assist her case, which is of course right. It's a recognition that if the court were to find what she has said and they've admitted as 4 to 5, then she has got difficulties with her own case. But she lays that at Aeden's mother on the basis that she's doing it to advantage her case. But the addressing the point that Lady Wise wanted to know when the critical timing issue became identified, the answer is on the very first day that evidence was given through cross-examination. Another Lady Wise question, which I should address, the time of dilatation in relation to active attempts. Lady and my Lords, could I invite you please to turn to 2357?
Sorry, 2537?
I'm sorry, I almost made the mistake. It's 2357.
Thank you, my fault.
And to paragraph 36 in our submissions to the Court of Appeal. In respect, as you see at the bottom of that page, 2357, all parties accepted that a diagnosis of full
Which
survival...
paragraph was this?
I'm so sorry. Do you have it?
I have the page, but not the paragraph.
It's the last paragraph, my Lord, at paragraph 36.
Thank you.
All parties accepted that a diagnosis of false cervical dilatation was made by the second respondent immediately upon his arrival. There is no issue about that. And this time was also consistent with the time that attempts at vaginal delivery started. So they come together whenever the attempts at vaginal delivery correlate with the time of the determination of full dilatation. On Aeden's case, 4 to 5. And on one further reference to this, on 2197.
Sorry.
I'm so sorry. I'm doing the same thing. At page 2172.
What's this in? Which document?
This is day 9 of the trial, 2172 to 2174. And in these pages, Lord, I won't immediately go to it, but Dr. Abdulla says that he arrived, did the examination immediately after the nurse did hers and recorded full dilatation and the attempts then started. So in short, how do these come together? Full dilatation and active attempts at the delivery are one and the same. And of course, we say 4 o'clock, and the other parties say 4:30. My Lord Stevens asked yesterday about the Appellant score and how that could or could not indicate fetal distress during labour. There's just one reference, my Lord, on that. It's in the High Court judgment. If we can go to that at page 64 and look at paragraph 102, where the High Court records a recognition by Dr. Wilkinson. With respect to the Apgar score, it remains low. If it remains low at 5 minutes, that being below 7, an infant may have fetal hypoxia before birth. And my Lord, I can't take that issue any further because that's as far as the evidence went on it. My Lord, sixthly, the misinterpretation by the Court of Appeal. Yes, we have discussed this at some considerable length. We all recognize the nonsense of adherence to the pleading in this case in respect of the scan, for the ridiculous outcome and for the sense of the parties in agreeing to find a mechanism whereby it could come within the pleading. But the important point here is not really what was happening with the Court of Appeal and what they were doing with sorting out this or not. The important and consensual point is that both the judge and the Court of Appeal recognized that unless there was an amendment to the pleading, and the parties recognized this, and the judge recognized this, that was what all the debate was in the transcripts on the very first half day of the hearing, before any evidence was called, and percolated the few days thereafter, that unless those amendments were made to the pleading, it could not be allowed because that is what the law said, and all the parties complied with it. That is the importance of the decision of the Court of Appeal, and accords in that respect with the trial judge's conclusion. And the Lord Doherty, because it's been mentioned, so far as witness statements are concerned, we repeat our submission that they cannot lead to a deviation from the pleadings. I mean, that's either, I've made these submissions yesterday, it's not necessary for them to be repeated. We say in respect of Trinidad, so far as the pleadings are concerned, they prevail despite the nonsense and the hard cases it will result in. But even if that is wrong, and the sensible approach is to take into consideration the development of the law as it is now in England, that one looks at the justice of the matter and one looks at prejudice, the justice of the matter is overwhelmingly in favor of this amendment not being made, so far as timing is concerned. As we submit, the claimant was dealt with unfairly. In every respect, the slightest deviation from the pleading was not permitted by the Court of Appeal, was not permitted by the judge, and recognized as not being permitted by Dr. Abdulla and by the clinic in respect of the scan. And yet, when it came, and I do take issue with Mr. Brown on this, that the timing cannot be said not to be fundamental, even though I take my Lord Stevens' point on the issue. When it was evidently fundamental, it was considered by the judge to be paramount. It was the basis upon which the issues between the competing pediatric opinions could not be resolved, despite Mr. Brown's fine advocacy that his experts, or not his experts, but Dr. Abdullah's experts would prevail. Why did Surgi-Med's amendment not make it a live issue? The answer to that, my lords, is that the Court of Appeal found in the first place that nothing flowed from this amendment. These issues were addressed yesterday. It took nothing. All it did was to expand the time available in the event that evidence could fill it up until 5:30. But the really important thing is that all the cross-examinations, the relevant ones, were done on unamended pleadings. So the clinic was bound by, as we say, their admissions at least until the amendments were made on day 6. And that applied to 3 o'clock, which, of course, as I've mentioned already, they did not amend, and to the 4 to 5 attempts. Lord Doherty, timing was more than a precondition. The paragraphs, of course, which you will look at time and again, as we all have, in the submissions of Dr. Abdulla, related on through 2496, 7, 8, 9, 10. But there's another aspect of the submissions of Dr. Abdulla which has not been addressed orally, which points to this particular point. I'm so sorry. If we go to 2529, we see at paragraph 74, I can just read it this way, putting aside the intricacies of the medical evidence, and just, if I may remind you, a lot of the submissions were put forward in like manner to Mr. Brown, arguing the merits of the evidence to the Court of Appeal. It's starting at paragraph 66 of those submissions, which we addressed your attention to yesterday, that there was something outstanding. And having gone through a lot of submissions, on behalf of Dr. Abdulla, he says this, putting aside the intricacies of the medical evidence, it was the consensus of all the parties based on the medical reports.
I'm so sorry, I haven't caught up. Which paragraph are you reading from?
Number 74, my lord, right at the top of page 2529.
Thank you.
Putting aside the intricacies of the medical evidence, it was the consensus of all parties based on the medical reports that 4 against 430 was the critical time period that had to be distinguished. That was done, the court preferred the latter. So this is a pulling together and a recognition that of all the other problems that there were, problems including the resolution of the medical evidence, that the only answer in the end to distinguish whether this event took place intrapartum or prepartum was to be determined on the issue of timing. Finally, my lords, I've addressed the issue of what in our submission was the procedural unfairness in the way in which we were held to our pleadings and Surgi-Med and Dr. Abdulla were not in the way in which cross-examination took place. There's the other issue, which I've said already doesn't apply, it appears, in the way in which pleadings are given preference to justice even and prejudice in Trinidad. But even if I'm wrong, I've mentioned the justice issue. The other issue is prejudice. The prejudice is, in this case, quite overwhelming. One has only got to look for a start at the elements of how it was that argued by Dr. Abdulla before the Court of Appeal that the prejudice would be because they had spent years building their case on the basis that the scam was normal, and now suddenly at the 11th hour it's not normal. And the prejudice means that they've got to go away, do all of this work all over again, and it's just not acceptable way of conducting litigation. And of course he succeeded that. But the prejudice is overwhelming. He needed to go back to his experts to deal with the scan. We needed to go back to our experts to deal with the 4:30 timing. We didn't get the opportunity to. We couldn't examine on the basis of the 4:30 timing. For one thing, we didn't have access to the principal document that the experts relied upon because it wasn't disclosed, the statement of February 2016. So we were hampered one way and the other in dealing with the change effectively on the fly. At the very least, if, as it emerged, for the first time at the beginning of the trial, that the defendants were, contrary to their admissions, going to put forward a case of 430, yes, perhaps I should at the time have stood up and said, no, this is exactly the same as a scam, which we were talking about this morning, which is what was happening at the time in Trinidad, and said, no, we've got to stop because there needs to be a formal application. I didn't do that. Maybe I should have done. But I did point out the conflicts, the evidence which shouldn't have been called contrary to the admissions which had been made. The experts were operating on completely different cases. It's often that experts will interpret the situation in different ways and form different opinions. But this is a totally different basis. The claimant's original expert evidence and the supplemental evidence was all served on an understanding between all the parties that the timing was 4 to 5. They didn't even have to entertain anything else because there was no issue at the time those reports were put forward. And the timings, so far as the defense experts were concerned, were effectively all based upon that note, which was not disclosed in February 16 at 4:30. Lord, if I may be permitted just a minute.
Yes, of course.
It's the question of disposal. If your lordships and lady take the view that the Court of Appeal were right to make a finding of 4, namely to restore the pleaded position in the light of their arguments, but there nevertheless does exist a residual argument, we've made our submissions on that, and that were to leave the parties, after 13 years of litigation, in a completely neutral status. The claimant doesn't win, the defendants don't win either, because issues which are fundamental to the determination of causation haven't been resolved, is a most highly unsatisfactory position. But if there were to be a remittal to the Court of Appeal to resolve this, on the basis of the timing, and a timing at 4 o'clock, because that would be the only basis upon which the remittal would be, because if the timing's 4:30, Aeden has lost. But if there were to be a remittal on the basis of 4, then consideration of the evidence on the papers, all of the expert evidence of the defendant, of the defendants, because of course Surgi-Med was dependent upon the expert evidence of Dr. Abdullah's experts, all of that evidence would have to be struck out because it's based upon a 4:30 timing. The evidence of Dr. Abdullah himself, that it was 4:30, would have to be struck out because the pleadings would say 4 o'clock. And if that were the case, all that would be left would be the claimant's original evidence, and the conclusion would have to be that the claimant succeeds in proving residual causation. Lords and Lady, unless there's any further matter we can help you with, those are our final submissions.
Thank you very much. Thank you, Mr. Powers. We're very grateful. We're very grateful to all counsel in this matter for your written and oral submissions. Very grateful to those sitting behind you for the work that's gone into the preparation of the case for hearing. This is an important matter. We will take time to consider the decision in due course. Thank you all very much indeed.